Steady. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you, Ronnie. Good morning and welcome to the Appeals Court. My name is Judge Desmond. It is my great pleasure to have Judge Shin to my right and Judge Singh to my left. We'll be serving as your panel for all 6 cases this morning. As you know, there are 15 minutes per side. That time is for you to use as you like. There's no rebuttal. We can tell you that we're familiar with the factual background of all the cases and have familiarized ourselves with the law in all of those areas. So you need not spend a whole lot of time on that, but again, the time is yours to do with it what you will. Our first case on the list is Commonwealth versus Merced Naves? Okay, Naves. I apologize for butchering his name. Attorney Corridon.
Thank you. Good morning. May it please the Court, John Corridon on behalf of Mr. Merced Naves. In order to evoke sympathy for its sole witness, Ms. Orellana, the Commonwealth elicited a fair amount of testimony that had nothing to do with guilt or innocence, and it relied heavily on that testimony in its closing argument. For instance, the Commonwealth elicited from Ms. Orellana that she was testifying for her daughter, Emily. And then in closing argument, the Commonwealth repeatedly reminded the jury that Ms. Orellana was testifying for Emily. But the way in which they did it was especially unfair. The Commonwealth basically said that Ms. Orellana was not testifying in order to acquire a visa to remain in the U.S., but was rather testifying for Emily. And
how did the visa in context come into play?
Well, Ms. Orellana acknowledged that she entered the country unlawfully, and she acknowledged that the DA's office was helping her apply for what was called a U visa, and she acknowledged that she understood that the U visa was for victims and that the DA's office was helping her, and she would not get their assistance without going forward.
And was that a line of questioning that was brought by the Commonwealth?
I'm sorry, Your Honor?
Was that line of questioning elicited by the Commonwealth?
Initially, yes. There was a brief question by the Commonwealth on direct, and then on cross, the defense counsel made one passing reference to the visa and asked about that, whereupon Ms. Orellana went outside the bounds of the question and said that she was eligible for other types of visa as well. And then the Commonwealth on redirect basically brought that out again, and Ms. Orellana was able to tell the jury that she was eligible for other types of visa. What she didn't do is explain whether those other visas were the same and why she thought she was eligible for them. In other words, the jury wasn't really given any context to assess the strength of the motive argument. The most that the jury could discern was that she was here unlawfully, she needed a visa, the DA's office was helping her get that visa, and that wouldn't happen without her testimony.
And was part of the defense that perhaps she was making these allegations so that she could obtain that visa?
Indirectly, yes. I mean, certainly defense counsel never said that she was lying, but the defense counsel certainly pointed out that the fact that she had a strong interest in remaining in the country and that colored her testimony, yes.
And when she was trying to respond as to some of the other visas that she might be eligible for, isn't that when she said that she didn't have any record and she had a clean history which made her eligible for a different kind of a visa?
I'm not sure if I heard every word of your question.
Didn't she suggest, the victim in this case, or alleged victim, didn't she suggest that because she didn't have any criminal history, that made her eligible for a different type of a visa as well?
She did say that she was here for 14 years with no criminal record, and that made her eligible. She did say that much, yes.
Okay.
So the Commonwealth in their closing, by stating that Ms. Orellana was testifying not to get a visa, but was instead testifying for Emily, I would suggest that this was unfair because it gave the false impression that if Ms. Orellana was testifying for her daughter that somehow was responsive to the claim that she had a motive to get a visa, when in fact it was not responsive. Even if we say she had no motive to get a visa, the visa argument was in no way diluted by the fact that she was testifying for her daughter, contrary to what the Commonwealth said in its closing.
Do you think that the Commonwealth asked that question to get that specific response?
Which question are we alluding to?
Why are you testifying here today?
Oh, certainly was the Commonwealth. I think it was a twofold. If I could take an educated guess, the Commonwealth had sort of a two-prong attack. The Commonwealth certainly wanted to demonstrate that she could. The Commonwealth certainly wanted to dilute the argument that she was motivated to get a visa, but they also very definitely wove that argument into the closing in a way that really didn't belong there. Even if the Commonwealth had successfully diluted the visa argument and diluted defense counsel's defense on that score, the fact that she was testifying on behalf of her daughter had nothing to do with the visa argument. But as it's presented in the closing, it basically gave the jury a binary choice: either think that she's testifying for her daughter or thinks that she's testifying to get a visa, when of course those two things are mutually exclusive. Further on in the closing argument, the Commonwealth tries to make hay out of the fact that Emerson was sort of a de facto victim. Miss Orellana's son Emerson was sort of a de facto victim by mentioning over and over that he was with Miss Orellana at the time of the incident. And of course, they're allowed to elicit this in testimony if it's simply to demonstrate context, but that's not really what they used it for. In closing, the Commonwealth incorrectly suggested that Miss Orellana's, that Emerson's presence there somehow explains Miss Orellana's delay in going to the police. Now, they didn't say that it excused her week-long delay, but what they did say is that Emerson's presence there excused her not going to the police immediately. And that, I would suggest, was an unfair argument, because defense counsel never suggested, nor could he suggest, that Miss Orellana was in any way remiss in failing to contact the police in the first hour.
Well, didn't she contact the police?
A week later.
Well, no. Didn't she go to the Lynn police?
Oh, yes. She went to the...
And when did she go to the Lynn police?
2 days after the incident, she went to Lynn.
So that's not a week.
Well, no, but the 2 days later when she went to Lynn, they explained that she had to go to Boston, and it was 5 more days thereafter that she went to Boston. So she never put her... notwithstanding her knowledge that she had to go to the Boston Police Department, she did not do so until 7 days after the incident.
And was that when she raised the issues about the child care? Was that when the Commonwealth elicited? What took you so long to go from, after they told you to go from Lynn to the Boston police?
No,
why'd you wait?
we're talking about the trial proper. When the Commonwealth was eliciting this testimony, the Commonwealth simply elicited that Emerson was with Miss Orellana, and then the Commonwealth asked, did Emerson actually witness the assault and battery? Defense counsel objected.
That was objected to.
Correct. Defense counsel objected to that.
Objection sustained.
Correct. So that put an end to that.
No answer, right?
Correct, and as far as the trial goes, correct. It was, so I'm not sure if that answers your question, but the Commonwealth, that's what happened during the trial proper. In the closing argument, the Commonwealth used Emerson's presence in a slightly different way to demonstrate or to argue that she could not contact the police on the day of the incident in the hour that it occurred. But no one was suggesting otherwise. I mean, she was with her child, and my client was on the bus with her, so obviously she's not going to call the police from there, and no one ever suggested otherwise. But the Commonwealth tries to make hay out of Emerson's presence needlessly. They also tried to cast Emerson, I don't want to say in the role of a victim, but certainly that they tried to suggest that he was swept up into the case when during the trial itself they elicit that that on the day of trial, Miss Orellana had to pick Emerson up from school and closet him somewhere in the courthouse, and then in the trial, in the closing argument, they remind the jury of that fact, even though it wasn't relevant. They also misstate the evidence when they indicate that when they accuse Mr. Merced of following Ms. Orellana on the bus. Ms. Orellana never accused that, made that allegation. She merely said that she got on the bus and that Mr. Merced was also on the bus. In fact, it might even be suggested that if he had followed her on the bus, she would have said something. So, best case scenario, he got on the bus and she got on afterwards. Worst case scenario, she was on the bus and he also got on the bus. But he went home. He got off at his stop. He certainly wasn't following her to Lynn. He got off at his stop. So to suggest that he was following her I would suggest, is not a fair interpretation of the evidence. Likewise, the Commonwealth indicates that
That's not eliciting sympathy, right? That just misstates the evidence?
I'm so sorry?
That wasn't eliciting any type of sympathy, the fact that they both left the apartment and they got on the same bus.
No, I would suggest that was to indicate, to plant to see that Mr. Merced couldn't let it go and was actually pursuing her on the way home. It just sort of gave a vague suspicion that this guy was still up to no good and still wanted a confrontation. They never explicitly said that, but I think that's the unavoidable implication. There was no reason whatsoever to use the word following to suggest that she was following her. Likewise, the Commonwealth does incorrectly state that Mr. Merced, in his closing, was asking the jury to look away from the photographs. He wasn't. He asked the jury to compare the photographs to the medical records and to find a discrepancy there. The Commonwealth equally misconstrued in his closing my client's opening statement. In the opening statement, my client said that he anticipated that the Commonwealth would introduce 3 types of evidence and that there would be inconsistencies in light of Ms. Orellana's testimony. But the Commonwealth's closing says that he failed to keep his promise to reveal inconsistencies in Ms. Orellana's testimony, and that's not a promise that he made. And finally, the Commonwealth in closing asked the jury to, quote, imagine what it must have been like when the wounds were fresh, when the pain was fading away. And they make this in the context of an argument that Ms. Orellana, tried to explain why Ms. Orellana waited so long to go to the police. But I would suggest that the police, that the jury in assessing whether it was important or not that Ms. Orellana waited to go to the police, they didn't really need to contemplate, what it was like when the wounds were fresh. That fell outside the context of that. So the real question here is, can I overcome this massive hurdle and demonstrate substantial risk? I think there certainly are some improprieties in the Commonwealth's closing, but doesn't amount to substantial risk. And I would suggest that here it does, because there were some inconsistencies in the Commonwealth's evidence. Certainly the medical records indicated there was no tenderness in my client's and Ms. Orellana's back, and that she appeared well, whereas the...
What does that suggest?
I'm sorry?
So what does that suggest?
Well, one of two things. I mean, on polar positions, one is that she's making the whole thing up, and on the other polar end of the spectrum, the doctor just did a poor job examining her. Perhaps somewhere in the middle is that we really can't get a handle on it. There's certainly an inconsistency there, but we as a juror would not know what to make of that. There was certainly that the discrepancy is certainly exculpatory. I'll leave it at that.
She had some photographs that were admitted and put before the jury? Yes,
I did try to include color copies. I do have color copies here. The only thing I was able to submit were black and white photos, but
they depicted the injuries.
They did, and they were rather serious. And I can certainly give the color copies of the court or mail them with the unit, but the color copies and the black and white copies demonstrate that there was some substantial abrasions to someone's back. And I'm going to say someone, not to be a smart aleck, but just to say that she wasn't depicted. There was no indication as to whether it was her in the photos and that they were taken that day, other than her testimony. And I'm not suggesting that that's dispositive of the case. I'm just saying that the jury certainly had to wrestle with the fact that the medical records were apparently at odds with this. There's also an inconsistency in the sense that...
the issue I'm having with your cumulative prejudice argument is that the majority of your arguments are based on, you're arguing that the Commonwealth did things to elicit the jury's sympathy. And we're reviewing this on a cold transcript, so we can't assess the tone of the argument or of the questions. and trial counsel didn't object. So isn't that very significant in the context of an argument like this?
No, I would humbly suggest that there's a difficult, counsel always has a difficult time keeping track of all the objections and objecting at just the right moment. Everyone's
But
fallible.
at the close of the argument, if it was delivered in a dramatic way and it was inflammatory, isn't it significant that trial counsel did not object at the end of the Commonwealth's closing? And how are we to assess it differently based on a cold transcript?
Oh, I understand your question now. No, I would agree. I'm certainly not trying to suggest that that there is anything inflammatory about the tone of voice of the prosecutor, and I would acknowledge that the absence of an argument does weigh against a finding that the tone of voice was especially prejudicial. I would agree with that.
Okay.
Would you say overall that the government's case was strong?
I'm so sorry?
Would you say overall that the government's case was a strong case?
I would say that it was not overwhelming. It was strong, but it was not so overwhelming that it would necessarily have reached the same verdict in the absence of these inconsistencies. I mean, remember, Ms. Orellana at one point testified that she waited a week notwithstanding her serious injuries, because she wanted to keep this relationship alive, but elsewhere she said, well, I knew he was cheating, and I just told him to go off and have, make a new life with this other woman. So her testimony was certainly not completely consistent.
What was the defense?
The defense was that, that Ms. Orellana should not be credited, that her testimony was not credible in light of largely her delay in going to the police.
I think that's your time.
Thank you.
Attorney Corden, thank you kindly. Attorney Martinelli.
Good morning. May it please the court, Jacqueline Martinelli for the Commonwealth. I ask that you affirm the defendant's conviction today. I would first start with the immigration information regarding the U visa that counsel had just addressed first. This was a testimony regarding potential bias and motive to testify regarding the Suffolk County District Attorney's Office support of the victim's U visa. And I would just note that there was one question on direct. It lightly touched the topic. On cross-examination, trial counsel went more in depth into the topic, which then opened the door for a fair redirect to ask the victim what other visas she qualified for. There was no objection, and given that there is no improper propensity evidence in terms of lawfulness in that case.
So leaving the visa aside, you don't dispute that the Commonwealth certainly went overboard, arguably out of bounds in some of its arguments? Or do you dispute that?
In what context, Your Honor?
In the context of this trial.
In terms of the closing argument?
In terms of the closing argument, in terms of some of the questions. What difference does it make if Emerson is in the courtroom while the trial is being conducted?
So in terms of Emerson, there was some testimony regarding that the victim was asked the age of her children.
What difference does it make that Emerson was in the courthouse at the time of this trial?
So, Your Honor, I would state that this was probably better left unsaid. However, that this was a very inconsequential part of the case, and it was relevant in terms of if he was present for the attack regarding the circumstances of the attack.
What does that have to do with he's present in the courtroom or in the courthouse on the day of the trial?
And again, Your Honor, I would just note that this was a statement that was asked in response to what the victim said, that the Emerson was here present in the court. Additionally, there was, the jury had already known that the victim did have a child named Emerson. There was also a jury instruction regarding not to make a decision on sympathy, and that was preliminarily in the instruction.
So it didn't matter. It makes no difference.
As I said, I believe it was better left unsaid, but I think this was a very inconsequential statement regarding the victim, the child present in the courtroom.
Commonwealth argued that the defendant followed her onto the bus.
Yes, Your Honor.
Is that anywhere in the evidentiary record?
It is not on the record, Your Honor. The testimony came out that both the victim and the defendant were at the defendant's family's home, I believe the sister and potentially a mother, that after the assault, they left at the same time. They were on the same bus. The victim was with Emerson. The defendant got off at Forest Hills, and then the
I
victim...
understand, but did he follow her home? Did he follow her onto the bus?
No, so Your Honor, there's no testimony. She did not say that she was followed. In the closing argument, the prosecutor did state without objection that they were together on the bus, and he did use the term followed her. However, this was a direct response regarding the delay in attack, which was one of counsel's main parts of his case, is that she must not be telling the truth because she didn't tell the Boston police until a week later. So given that they were on the same bus, that was one of the reasons why she didn't call the police immediately after the incident, because she was on the same bus with the defendant. Moving on with the counsel's argument regarding the photos and that the prosecutor misstated the facts regarding the look away from the photos. Again, part of counsel's argument was that there are inconsistencies between the photos and the medical records. The medical records were for an OBGYN appointment, not for the injury she suffered from this attack. It was a fair argument based on the evidence that came out, so there was no substantial risk on that statement, and he did not misstate the evidence.
Was it necessary to say that he flogged her like a man whips a beast?
So, Your Honor, regarding that statement in the closing argument, and I believe counsel did, the prosecutor also mentioned a statement to that effect in opening as well. So on it is a fact and evidence that the victim said that she was hit with a whip, and it was very hard, and he whipped her multiple times on her back. So regarding this was not objected to, and it was not an improper appeal to sympathy, given that not only did the victim say she was whipped with a phone cord multiple times on her back, that this was just enthusiastic rhetoric, and it was proper. Again, there are jury instructions here, not only in the beginning, but also at the end of the trial, saying that the closing argument is not evidence.
Counsel,
I'm sorry, go ahead.
the ultimate question, because of the lack of objections during the trial, is whether it created a substantial risk of a miscarriage of justice, correct?
Yes, Your Honor.
All right. And you agree that the entire case was made out of the testimony of the victim. Is that correct? There was a single witness.
Yes, Your Honor, and there were the photos, but it was the victim who authenticated the photos.
So all of these appeals to sympathy and mentioning of things that were not, central to the actual crime, could have a big impact on the jury's assessment of credibility. That's what the whole case was about, the assessment of the credibility of the sole witness. So how can you say, or how can you take the position that all of these things are, in the end, inconsequential? It comes down to credibility, and all of these alleged errors brought out by your brother counsel could lead a jury to be overly sympathetic and not be focused on the actual evidence.
And, Your Honor, to respond, I think when we're looking at if this was a substantial risk, we look at different factors, including, one, if the defendant objected. As Your Honors are aware, there was no objection in most of the testimony from the victim, as well as the defendant's the prosecutor's closing argument.
But the other argument being made is ineffective assistance of counsel, of course.
Yes, Your Honor, and I can turn to ineffective assistance. I would just note that at this point, given that this is the first time we're seeing this on appeal, it's in its weakest form. We did not have a motion for new trial for the trial counsel to testify if this was potentially strategy or a strategic decision. He did have a clear defense from the record, given that he was trying to elicit biases potentially for infidelity, and as well as the U visa.
Any affidavit from trial counsel?
Correct, Your Honor. So there was no motion for new trial at all, so this is the first time we are seeing this. Additionally, and regardless, as discussed, that these errors were not of any significance, so any objection would be futile. Therefore, he did not fall below a lawyer. There's no ineffective assistance of counsel here. But turning back to your other question regarding...
Hold on, let me just pause. Did you say these errors are of no significance? I think that probably depends on what seat you're in, right?
Yes, Your Honor. And just in terms of the closing argument, again, this was not objected to. The prosecutor was arguing fair inferences based on the testimony, as well as using enthusiastic rhetoric. In terms of the...
How is it relevant that her motive for testifying was her daughter in her belly who suffered the most?
And I think it's important to note when that came out and when that question was asked, and that was on...
Question, it seemed like it was not solicited directly. But how is it proper for the prosecutor to repeat that in closing argument? How is it relevant at all to the case?
So in terms of, that was a question that was directly related to the U visa testimony.
I understand. So putting aside the question, let's say that the question was not designed to elicit the testimony, that she volunteered it. How is it proper for the prosecutor to then rely on it in closing argument?
Well, I think it was proper to, for the prosecutor to then respond to counsel's closing argument, where he made very clearly that most of his closing argument was regards to the victim not having any immigration status prior to this, and her all of a sudden got so much better based on her cooperation. So that question is directly related to responding to the defense argument. And then I understand that it is an element of the crime, being pregnant. Understand that just being pregnant isn't the element, but I do think it's also related to...
Well, it was already established she was pregnant, right? You didn't need the testimony that it was her unborn daughter that suffered the most.
Yes, Your Honor. And I also think that with the jury instructions, both preliminary and at the end, given that the prosecution's closing arguments is not evidence, would suffice as well. And then turning back just to the substantial risk analysis, I would also point that another place to look into is whether the issues were collateral issues or the heart of the case. These were all collateral issues. Again, Emerson being present in the courtroom, again, it's inconsequential to the case, the heart of the issue. And there were jury instructions throughout the entire case that would mitigate any potential error. So I would suggest that there's no substantial risk in this case.
I'm wondering whether you can consider the credibility of a witness, the sole witness, the recipient witness, the critical witness, the credibility of that witness to be collateral.
So, well, I think just in terms of the statement that I was referring to was Emerson in the courthouse, but in terms of the credibility, yes, credibility this was a one-witness test trial. The corroboration was the photos that the victim did authenticate herself, saying that she had those pictures taken 2 days later after the incident in Lynn. But given that it was proper for the prosecution to discuss in his closing credibility issues that counsel has raised regarding potential infidelity, that counsel wanted to state the Lynn medical records versus the photos and the inconsistencies there, as well as potential motive or bias for testifying regarding her immigration.
I see you have a few more minutes. Anything additionally?
No, Your Honor. If there's no further questions, I would rest on my brief. Thank you.
Thank you both. The matter stands submitted. Appreciate your arguments. They've been very helpful.
Thank you.
The next matter we will hear is 22P1238, Commonwealth versus Christopher Medeiros. So maybe you can help me with the pronunciation of your last name.
Sure. Tara Ganguly, Your Honor. Yes.
Okay.
Good morning. May it please the court. Tara Ganguly for Christopher Medeiros. Your Honors, if this was the type of police hearing that this court and the SJC requires, then the case of Commonwealth versus Felice, Felice 1, would really have no meaning. There are a constellation of factors that the motion judge was supposed to consider in the May 2022 hearing, which was 5 years after the defendant was sentenced.
So let me just, so I understand in my mind's eye kind of procedurally where we are. So he got a 7-year term of commitment, is that right?
He has a 10-year term of commitment and a 7-year term of probation to start after commitment,
Okay.
which he will be out in early 2024.
And so when's the relevant time to determine what if there's going to be any exclusion zone or what have you? I mean, what difference does it make if he's going to be doing 10 years on year 1, whether there's an exclusion zone, when the victim may move throughout the next 10 years? Wouldn't the pertinent time be on the day of his release?
That's not, if defendants are supposed to file motions on the day of their release, they are,
Shortly before his a month before his release, 2 months before his release, not 5 years.
okay, certainly not 5 years, but so he files this motion in
2021.
sometime, yeah,
Yeah, and
early
he hasn't been
2021.
released yet, right?
He has not been released
So
yet.
if the relevant time is not when he's about to be released, why wouldn't the relevant time then be at the time of sentencing? Because you're asking us to apply Felice retroactively, right? So why does it matter what the facts were at the time of the motion hearing when you're asking us to apply it retroactively to the time of sentencing?
I'm not asking you to apply it retroactively to the time of sentencing because the law was different at the time of sentencing. Felice didn't exist. Section 47 mandated the GPS.
So then it's a motion to, isn't it a motion to modify the conditions?
Yes.
So who has the burden on motion to modify probation?
The Commonwealth does.
On a motion to modify?
On a Felice motion, the Commonwealth has the burden of.
But I mean, you call it a Felice motion, but that's confusing to me because it seems like the relevant time would be at the time of sentencing, which would not be a motion to modify.
I'm not
Right.
sure.
It's a
I quite
challenge to this.
understand your-
So I mean, what's the relevance of November 2021? When the motion was
My client
filed?
realized that the law had changed. You know, he learns, however they learn in prison, that the law had changed, and says, hey, I never got the benefit of this decision in 2017 when I was sentenced.
Right.
But this is what the law is now. I want a judge to review my case to determine whether these constellation of factors exist in my case to require GPS monitoring for 7 years.
But there had been no GPS monitoring at that point, right? I understand it was a condition of his probation or his release. I get it. The judge had to do it, like you say, at the time. The statute mandated that GPS be imposed. But nevertheless, at this point, he's not getting released anytime soon, and he didn't
Well, he
have...
is now, but
But at the time of this argument, he wasn't about to be released.
in May of 2022?
That's when he was about to be released.
No, I'm asking you
No,
when.
no. So that's backwards. I'm asking you.
Okay.
When was he scheduled to be released?
He is currently scheduled to be released in March of 2024,
Okay, and he brought this motion when?
in November of 2021.
Okay, so he wasn't about to be released?
No.
Okay, so there was not going to be any GPS, no GPS had been placed on him, is that fair to say?
Correct?
And wasn't going to be placed on him for another 3 years?
Correct.
So isn't that the time that it should determine whether there would be any exclusion zone? How would they know what area to exclude him from when he's going to be held for several more years?
They don't, but the SJC made it very clear in Commonwealth versus Roderick that the Commonwealth has the burden of bringing certain facts to the motion judge.
Okay?
And
Regarding a
the
victim's
difference in
whereabouts.
Roderick was the motion happened to coincide with the defendant's imminent release. Okay, so when does the search happen? Is it when the condition is imposed or when the device is placed on the defendant?
the constitutional search when the device is placed on the defendant.
So then why isn't this motion premature? Either we're looking at it at the time of sentencing, because that's when the condition was imposed, or we would look at it at the time of imminent release. I mean, I don't see what the relevance is of an interim motion brought while he's still incarcerated.
I guess there's no guidance from the SJC or this court to defendants at any stage of their proceeding regarding when the proper time to bring such a motion would be. If this court decides this motion was premature, in the future, all of you defendants out there, you should bring these motions 30 to 60 days or 30 to 90 days before your release. If the court wants to make that ruling, I invite you to make that ruling, but.
Well, I mean, I don't think we have to go so far. Even if we assume there's a ripe challenge now, we would assess it at the time the condition is imposed. So what the facts were before the sentencing judge, not the motion judge. Right? Why can't we do that?
The facts before the sentencing judge, no one ever delved into what is now part and parcel of the constellation of factors. No one ever delved into that at the time of sentencing.
So you're saying that
The law didn't exist.
We review for abuse of discretion?
No, you review
Novo.
de novo. Yes.
So at the time, you're saying that the sentencing judge made no determination at all, did no balancing, because at that time that wasn't required. It was an automatic. But
Correct.
despite that, can we not look at what was before the sentencing judge and determine whether there was sufficient evidence to have justified the imposition of the GPS?
I think you can look at what was before the sentencing judge to a certain extent, but the only thing before the sentencing judge was the assistant district attorney's recitation of the facts that would have been proved at trial. There was no discussion of my client's past criminal
They knew where
convictions.
the victim's home was, at least.
Excuse me?
They knew where the victim's family home was.
Yes, there was a
And so would you
stay-away
agree
order.
that had he been released then, that they could have established an exclusion zone around her family home?
The Commonwealth never asked for an exclusion zone.
Well, he wasn't being released, right? I mean, he was being incarcerated.
Correct.
But
But
had he
I've
been
certainly
released at the time, that would have been possible, right? Because they had the address.
Correct, but I've certainly seen many transcripts, and I'm sure you have too, at the time of sentencing where the Commonwealth does ask for an exclusion zone. And there's sometimes discussion back and forth with the judge, Commonwealth, this person's going to be incarcerated for 10 years. You want the same exclusion zone? And they say, Your Honor, if things change, we will come back. I've definitely seen that.
But this was a little complicated. It wasn't simply stay away from her home. She had a family home. She was in a program. It was complicated. So it wouldn't be the case where the Commonwealth would easily be able to say this would be the zone. They know there's going to be some movement even then.
Well, in the stay-away order in 2017, they did ask for a certain address, which was the victim's mother's address, I believe. They didn't ask for a stay-away zone from whatever program she was in at the time. It was just the one address was for a stay-away order. But no one has ever asked for an exclusion zone.
How about substantively, in terms of the decision that was made here, given the nature of the charges? Of course, in Feliz was very different. It was a child pornography sort of case. Given the nature of the charges here, aggravated rape of a child, couldn't the judge have made this determination based on the nature of the charges?
That is, excuse me, that is essentially the Commonwealth's argument on appeal, is that this was the worst of the worst. And I am not arguing against that. The defendant pled guilty to these charges. However, in Roderick, the defendant was convicted of rape. It was not rape of a child, but it was still rape. But if the SJC wanted to carve out an exception for the worst of the worst, it would have left Section 47 intact for this crime, for whatever crime it chose to consider the worst of the worst. The facts of the case are not enough. There's no evidence about the particularized risk of recidivism, his criminal history, any violations of probation. There's none of that. We have none of that. And those are the factors that the SJC says a motion judge has to evaluate. And the Commonwealth did not bring, the exclusion zone is one thing, but the Commonwealth could have and should have, from their perspective, brought, if it exists, but it's not in the record, evidence regarding past criminal history, past probation violations, anything else they wanted to put in front of the court, but they didn't.
So in Roderick, the court said that if an exclusion zone could have been established, then the case would be straightforward, right? So it
Correct.
seems as though, I mean, Roderick was an unusual case in that they couldn't find the victim at the time of the motion hearing, but
Yes, there's no evidence here they even tried. At least there, the ADA said,
well,
I'm
you know,
trying,
again,
Your Honor."
I'm a little perplexed by the timing of this motion, but putting that aside, doesn't Roderick then suggest that the severity of the crimes committed plus the ability to establish an exclusion zone together is enough to justify the GPS?
Perhaps, in that case.
Without looking at prior history and the other factors, right?
I don't think that Roderick makes it that clear. I think the other factors are still the other factors.
Well, were there other factors relevant in Roderick other than the exclusion zone and the nature of the crimes? Was there evidence about past criminal history?
I'm not 100% sure, Your Honor,
Me
but I
neither.
think the case itself makes it clear that it's a totality of the circumstances. And, you know, I understand the court's concerns about the timing of the motion, but again, if the motion was premature, if Your Honors were to decide that this motion was premature and therefore the motion judge was correct in his ruling, I would ask that you allow my client to bring forth another motion, you know, say this motion should be denied without prejudice to renewal at the time that he is actually released. There's no,
Is there
It's not fair.
is there some sort of prohibition on motions to modify probation conditions? I mean, can't your client bring one at any point?
yes, he can, but I think depending on Your Honor's wording of a decision in this case, it would help my client to say that the timing was perhaps premature. Depending on how you word a decision, that might help a future motion judge.
So, at the end of the day, we have a defendant who is in his 7th year of a 10-year term of incarceration for rape of a child repeatedly, a child that he had developed some relationship with by virtue of living in the same, did they live in the same building? Wasn't he the
He was the care aide for her
of
brother.
her disabled brother?
Correct.
And no GPS has been placed on him yet.
Correct.
So what harm has he suffered?
He will suffer harm as soon as the GPS is placed on him.
Got it.
But there's nothing in the law saying that his motion was premature. If you want to decide and make a ruling that his motion was premature, obviously that's your prerogative, your decision. But I don't think it's fair to just say to all defendants off the bat without giving them guidance in this respect about when they should be filing these motions. If there are no further questions, I'll rest on my brief. Thank you.
For the Commonwealth, Ms. West.
Good morning, Your Honors. I'm Abigail Rooney West on behalf of the Commonwealth, along with Paul Lynn at the bench, requesting this court affirm the motion judge's decision denying the defendant's motion to vacate GPS monitoring as a condition of probation. This court, as determined by the case Commonwealth v. Felice, reviews questions of law de novo. However, this court also... Sorry.
Go ahead, Ollie.
Okay.
Go ahead, Ollie.
However, this court also owes a degree of deference to the sentencing judge. As determined in the case Roderick, this court accepts findings of fact by judges who saw and heard the witnesses,
All right,
unless
so
those
I'm
findings...
going to jump in here. So, how much deference do we owe to a sentencing judge when at the time that he imposed the condition, the law was different?
Yes, although the sentencing judge did not have Felice before him at the time that the probation conditions and the sentencing was in place, he was still there. He saw and heard the defendant and the witness make statements before him, and he made a credibility determination that the defendant was not remorseful and was not taking responsibility for the crimes that he committed. And that weighs towards the Commonwealth's interests going forward regarding risks of recidivism and just protection of the victim in general.
Okay. So, now the motion judge, we fast forward a little bit, and we have the motion judge who now has the benefit of Felice.
Yes.
Right? And what balancing did they do?
Yes.
Judge Doohan did.
Yes. Thank you, Your Honor. The motion judge, as you all have, had the full record before them regarding...
Well, this motion judge didn't have a full record.
Yeah, right. Well, they had like the transcripts and that before them, and could weigh they stated in their decision that they weighed the police factors and determined that GPS monitoring in this defendant's case was justified.
But our review is de novo?
Yes.
Okay.
So you
So
don't.
what are the factors? Tell me.
So the factors that this court weighs are the defendant's privacy interests and against the Commonwealth's interests in GPS monitoring. And those interests include protecting the victim and the victim's family and protecting against the risk of protecting against recidivism from the defendant.
So why not ask for some type of an exclusion zone?
So this court could place when the sentencing judge established the probation conditions, an exclusion zone could effectively be created around the victim's home, as stated, to prevent further victimization of the individual.
But absent that, how does it protect the victim?
The creation of the exclusion zone.
Absent an exclusion zone, how does GPS monitoring protect the victim?
So absent the exclusion zone, if GPS monitoring protects the victim, because GPS monitoring establishes establishes deterrence for the defendant regarding future violation, and it does provide a sense of security for the victim.
But hasn't the court cautioned us on the value of the deterrence piece?
That is correct, yes. However, due to the extreme nature of the abuse and assaults here, it seems like GPS monitoring is appropriate in this case.
It may seem like that, but you have to kind of make the argument, right?
Yeah, yes, so.
Is it the Commonwealth's position that we're looking at the facts as they existed at the time of sentencing or at the time of the motion hearing?
At the time of the sentencing. Before the sentencing judge, yes.
Okay, and then, so he's going to be released next year?
Yes.
Can he bring a motion then as well to modify the probation conditions? Let's say that the victim has moved out of the country. Mm-hmm. Would that be relevant to the Felice analysis?
I'm sure that would factor in if he brought a motion later. However, he did bring the motion in 2021 as stated. So we're looking at the facts of this case specifically, and if he brings a motion later, that's another determination that can be made. Okay. But looking at the Felice factors, we did have the exclusion zone as stated that could have been created around the victim's home, and the victim repeatedly stated in her victim statement before the sentencing judge that she wanted to go home, that she didn't want to be in the program, and she wanted to be with her family. And I think that's a strong reason to protect this victim. Additionally, regarding protection from recidivism, here the court determined that in Roderick that as the degree of dangerousness increases, so does the weight of the government's interests. Here, this is one of the worst possible offenses that someone could commit. And as the Supreme Court stated in Ferber, and as was discussed in Felice as well, that the prevention of sexual abuse and exploitation of children constitutes a government objective of surpassing importance. Additionally, Felice included other factors that this court considers, such as contact offenders are more dangerous, and repeated behavior is also adds to the level of dangerousness. Here, the defendant, in a position of power, repeatedly attacked a developmentally disabled 11-year-old girl over a 9-month period of time until he was caught. The risk of recidivism in this case is extremely high, and the sentencing judge finding that he also was not accepting responsibility.
Who says the risk of recidivism is exceedingly high?
The Commonwealth says.
The Commonwealth
Yes.
says it? Okay.
Has he been classified by the Sex Offender Registry Board?
So he has not been classified yet, so that takes place later.
He's going to be released fairly soon, right? So
So that should take place soon, I would suppose. However, they have not classified him, but that could help this court make a decision. But given the nature of the sexual assaults involved here and the rape, it is clear that he poses a high degree of dangerousness to society and the victim.
So, given what you just said, would it make a difference if the victim had moved out of country?
If the
In
victim,
terms of the utility of the GPS?
if the victim moved out of the country, that would be obviously different facts. But victims move around. This is still someone who committed this crime, and therefore requires. I think GPS monitoring here would be appropriate given just the nature of the offenses. And
So what I'm saying is, if take the victim out of the picture altogether, is there still a Commonwealth interest in maintaining a GPS?
Yes, Your Honor. I still think that there is an interest in the Commonwealth imposing GPS monitoring just due to the nature of these horrendous sexual assaults. It's not just because it was one victim doesn't mean, I don't want to presume, but.
So is it the nature of the assault or the nature of the circumstances that he worked for the assault? That is to say, it was his position of trust. He had access to the home. He was constantly around this child because of his relationship with her brother. This is the type of work that he engages in that puts him in the presence of maybe vulnerable or at-risk kids. Is that the issue? This wasn't a stranger crime. He didn't just go grab somebody off the street, right?
Yes, Your Honor. And this court does consider other factors, such as the relationship to the victim when determining the risk of reoffense and dangerousness. And
were those arguments made by the Commonwealth at the time of the motion?
At the time of the motion hearing?
Yes.
I would have to check the record again, but I believe that they brought arguments similar to what I'm making today. Yes, but in any event, this type of sexual assault, as I mentioned, is one of the worst possible offenses and requires GPS monitoring in this case. And here, the Commonwealth's interest in GPS monitoring is exceedingly high, and it significantly outweighs the defendant's reduced privacy interests as a probationer. And
the legislature had determined that GPS was not going to be mandatory for these types of offenses, correct?
For
this offense, it's not mandatory.
It's not mandatory. However, they did impose
Why is that? So why is it not mandatory?
Because it raises questions of constitutionality and therefore requires the individualized determination for the
We can't just
defendant.
say, based on this kind of offense, it's clear that he should definitely be on GPS, right?
Yes, that's correct. However, given the facts of this case, this defendant does need to be on GPS.
Because it has to be an individualized assessment.
Yes, that's correct. Yes, and if there are no further questions,
Hearing none.
the Commonwealth
Thank you very much, Ms. West.
Thank you.
The matter stands submitted. Appreciate your arguments. The next matter on our list is 2023 P0550, Commonwealth versus Carter. Finally, an easy one for me.
Yes,
Attorney
right.
Cox.
Good morning. May it please the court, Jennifer Cox appearing on behalf of Philip Carter. As the panel is familiar with the case, the evidence in this case showed that Mr. Carter's brother, Peter, committed a breaking and entering in a home in Andover. He was indisputably assisted by an unseen joint venturer because on home security video, there's a pickup truck shown at the scene and with Peter going to the truck. So the Commonwealth's theory of Philip's culpability here was based on the theory that he was the unseen driver of the pickup truck on that night, based on an occurrence that happened the following day in Reading, in the town of Reading. So the defendant's first issue on appeal is that he argues that the Commonwealth's evidence failed to prove beyond a reasonable doubt that he was the joint venturer to the housebreak. And, you know, as you're familiar with, there is no direct evidence of this, so the question for this court is whether the circumstantial evidence tilted the scales beyond mere speculation that he could have been the joint venturer to prove beyond a reasonable doubt that he was the driver during the housebreak. So Philip had no connection to the crime itself. He had no connection to the
Well, when you say no connection to the crime itself, wasn't he found with some of the proceeds?
Right. What I was about to refer to was that he was not connected to the McRoys, to Andover, to Winchester, where the emergency beacon was activated, and it was not connected to the truck. It's the driver, the owner of the truck. So to answer your question, so the next day he is found. There's an incident in a Dunkin' Donuts, so after that the police pull over a truck, and at that time he is driving the truck. To the Dunkin' Donuts, his brother is driving the truck. When he is pulled over after operating, I think for 2 minutes, the officer testifies to, there's a series of events, and then they flee from the vehicle after being stopped for the incident at the Dunkin' Donuts. The officers at that time in Reading were not aware of the incident in Andover, so had no reason, they were not pulling him over in connection with that. Then the officers find the fruits of several of the fruits of the housebreak in the bed of the truck in closed containers, essentially in duffel bags and in backpacks. The only item visible from the duffel bags was some bottle rockets sticking out of one of the bags, which were not fruits of the housebreak. So the question really...
Have anything in his pockets?
So the judge also, so this was a bench trial, so the judge also cited to items he had on his pockets at his arrest, which included money. And that included a $100 bill, among other money, $100 bills and some $2 bills. So the victim, Mr. McRoy, described missing from his home were 9 or 10 $100 bills and two $2 bills, which were unique collector's items in that they were on a single uncut sheet. And so part of our argument for why the evidence was insufficient here is that the description of the money missing as compared to the money found on Mr. Carter is not as incriminating as the court inferred.
Well, the description was the victim indicated, I'm missing 9 or 10, but 12 were found.
Right. So certainly we have to concede 9 or 10 could be consumed in the 12 that were found, certainly. So the better argument regards the $2 bills. So
$2 bills are not that common.
Certainly, I do acknowledge that that's not a commonly seen unit of currency, but here, money is ordinary. It's a fungible good. We're not saying that the homeowner, should have known the serial numbers of the $2 bills that he's missing.
I understand that, but 10 to 12 $100 bills are taken from the house along with some $2 bills.
9 to 10, and then 12 are found. Yes, and then
the next day they find a guy with 9 or 10 $100 bills,
right,
along with some $2 bills.
Right.
Just sheer coincidence.
I mean, certainly it could be, and the standard here is proof beyond a reasonable doubt. So
that was put before the jury?
This was a bench trial, so this was for the court,
fact
yes.
finder?
Yes. And so the issue with the $2 bills, just so I can finish my thought on that, is that the homeowner described them as very unique items. And here, the Commonwealth bore the burden of proof on this, and they didn't introduce the money itself. They didn't introduce photos of the money. They didn't ask Mr. McRoy, they asked him, did you get your tools back? Did you go to the police station and identify property? And he says, yes, as to the tools. They don't ask him, did you also get your money back? Did you get your, were your $2 bills on the uncut sheet together? Officer Nelson, the Commonwealth, attempted to ask him regarding the recovery of the money was, I want to get the answer specific, but, was there anything odd about do you remember anything particular about the $2 bills was the question. And he replies, not that I remember. I would suggest that I've never seen money on an uncut sheet. I think that would be something
It could have been folded, right?
The Commonwealth in their brief says, perhaps this was the folded money. And, it's possible, but also I think that the money, as I believe the photocopy of the photo of the money that was introduced in evidence is in the appendix, and that just shows, a flat bag with the money in it, and it, lists the denominations of the money on that. So the money isn't unfolded at some point, so, someone saw the money.
He could have cut it too, right?
That's possible, yes, that is possible.
But
yes.
there was evidence that there were two $2 bills
That's correct.
in the home, and he was found with two $2 bills,
That's
right?
correct, yes. It's just that where there was a description of it, and it didn't match. And again, we're not
Well, you say it
arguing.
didn't match. Didn't
Yes.
one of the officers say there was something unusual about it? I just don't recall what it was.
No, the question was posed to him, do you remember anything particular about this? And he says, not that I recall. So the Commonwealth in closing phrases it as you just did, which is, our second argument in the brief is that is an inaccurate recounting of the question and the answer. The Officer Nelson did not say that he remembered that there was anything peculiar about it. He was asked, was there anything peculiar about it? And he said, not that I recall. So to me, that's an answer of no. The $2 bills they were $2 bills, and that was unusual, but nothing about them particularly was unusual.
Would you agree that goes to the weight of the evidence?
Yes, and so here our argument is not that this is an impossible verdict, but where the standard is proof beyond a reasonable doubt, there's no direct evidence, so we're dealing with circumstantial evidence, that this was not enough to tip the
What about when you
scales.
add in consciousness of guilt?
Yes, so the consciousness of guilt evidence has to do with his flight, after being pulled
Well,
over
even
by the
before
police.
that, right? Didn't they both give false explanations for all the bags and containers?
Yeah,
came
so the
from?
officer is asked, did you ask them? And he says they said, that they had been helping a friend move all night. They don't break out particularly what the question was. It seems to be, was this the duffel bags? So then we also are dealing with the flight from the scene, and I would argue there, Officer Nelson says when he pulls them over, he told them, I'm stopping you in relation to what just happened at the Dunkin' Donuts, which was either a disturbing of the peace or impaired operation. He says that both brothers have pinpoint eyes, in implying evidence of drug use or, driving under the influence. And then there's also the incident in the Nissan the prior night that includes one brother, they seem to be implying Philip, but at least one Carter brother fleeing from that car, which had also incriminating evidence in it. It had hypodermic needles, it had wrong license plates attached to it, and most incriminating, the defendant's girlfriend had reported that he stole that vehicle. So the argument is where all of these interceded between the housebreak the night before committed by his brother and someone else, and the flight. That's a leap to say that that's consciousness of guilt of the breaking and entering, where several more likely things, for better or worse, for this defendant intervened, including the officer saying, "I'm pulling you over for the crime that just happened at the Dunkin' Donuts," or for that.
So you argue at most, this gets you a receiving,
Yes.
not a breaking and entering.
Which was charged in Red or Woburn, I think, is the court that occurs. So yes.
So the housebreak occurred on one night.
I believe it's on the video at like
In the
3:45 in the morning, and then also it's seen at 6 in the morning.
I've seen the
Yes.
video. And then the Dunkin' Donuts incident occurred when?
The next morning at 7 a.m. So it's like 25 hours later. And then the Nissan incident is 9 p.m. in between those things, yes. So I can move on to the second issue if there's no questions about that. So the second related issue is that the Commonwealth in summation misstated the evidence concerning the money found in Mr. Carter's pocket, and that this is under the substantial risk of miscarriage of justice standard, but we argue that it amounts to that because this evidence, particular evidence, was material to the court's verdict when she explained the verdict. So, obviously we discussed the $100 bills and the $2 bills. The $2 bills, is the worst, we're arguing is the more important evidence here.
Do you assess the errors in any different manner, given it was a jury waived
Bench
trial
trial.
and not
Yes.
jurors?
Yes, and I would say what differentiates this case from, the cases that say this is a bench trial, so we presume, appropriately, that the court appropriately instructs itself on this, is here that we do know that the judge relied on this particular evidence because the court, in explaining her verdict, specifically cites this, saying, she cites to the uniqueness of the $2 bills in addition to the number of $100 bills as significant to her finding of guilt, that the Commonwealth had met its burden of proof beyond a reasonable doubt that he was the unseen joint venture to the breaking and entering.
Well, $2 bills are unique. Just, they are, right? So
Right,
I don't know
yeah,
how much
yeah.
meaning you can glean from that.
Well, she does say the uniqueness of the $2 bill, so, that could be read as you're saying, but I certainly took it to mean the uniqueness, not inherent of $2 bills, but the uniqueness of these $2 bills as described by the homeowner. And so
Coupled with the same number or approximate number of the $100 bills.
Right, yes, but so where, again, we do acknowledge this was a bench trial, so it gets the more favorable standard. But here, where the judge does cite to this evidence as an important factor in the verdict, we make the argument that this is a substantial risk of miscarriage of justice.
So doesn't the judge also say, I'm going to get to one of your other arguments, which is the
The motion for a new trial?
failure to disclose the officer who had been terminated and
Right.
had an active, or played some role in this case?
Yes.
But doesn't she say, even if I had known that, it wouldn't have made a difference in my decision?
Right, so moving on to the third issue with the motion for a new trial, she did say this would not have been a factor here, and so the defendant's argument, again, acknowledging the standard of review that we are dealt with here, says that, where that is manifestly unjust, which is the standard, even, the judge saying that where we know that she did rely on this evidence in her decision.
What role did that officer play?
So Officer McEachran came to the scene after the truck is stopped. He is dispatched to the Dunkin' Donuts to get statements from the people there. I apologize that I don't quite remember yes, that happened, and then he comes back, and then he photographs the truck, the contents of the truck at the scene, and is a participant in the inventory at the police station. So our argument is that this is significant, his role is significant because he handles the evidence, and the judge's, again, her decision was based on the evidence in the truck, and this was not part of the judge's comment, but the Commonwealth's evidence showed that most of the evidence was in the bed of the truck. And certainly, I'm not saying the officer placed, duffel bags of evidence in the truck. Those were there.
Was that disputed at all?
No. And so the issue is that we argue on appeal is that it is significant that one item is found in the passenger compartment of the cab of the truck, which is Mr. McRoy's passport. And so I don't know why one piece of evidence, one stolen fruit is located in the passenger cab, but certainly that is used to demonstrate his knowledge of the stolen.
Didn't Detective Holmes also testify that the passport was found inside the truck?
He did, but Detective Holmes's role only began at the police station, whereas McEachran, handled the evidence and photographed it at the scene. So yes.
Holmes was not at the scene?
Correct. Yes.
Okay.
So again, that's we've again recognized the standard of review here in that it was a bench trial and that this was the judge who sat at trial and was familiar with the case. But where she relied on this particular evidence and this officer, is indisputably found to have dishonesty in the performance of his duties, as the, I believe it's either the Lopes or the, in the matter of grand jury investigation case says, the court will parse out whether the dishonesty relates to the performance of one's duties versus, for example, the overtime scandals that happened recently. Here, this was in the performance of his duties, so we would argue that that would be a factor and that the decision was manifestly unjust.
Was the officer involved in handling the $100 bills and the $2 bills?
I'm not sure of that.
reporting about
Officer
them in any-
Nelson is the one who takes them out of his pocket, so I think I would say no, I don't believe McEachran was involved in that. I don't know who photographed that evidence, but again, it wasn't photographed until it was in the bag. So I think based on Officer Nelson's testimony that he was the one who collected it, I don't think I can fairly say that McEachran had a significant role in that. Okay. All right, and I see I'm running out of time, so if there are no further questions, I'll rely on the brief. Thank you.
Thank you. Attorney Cohen?
Good morning, Your Honors. Jennifer Cohen for the Commonwealth. Although the case against the defendant was circumstantial, the Commonwealth argues that there was more than enough evidence here to meet the sufficiency burden, especially where the standard is in the light most favorable to the Commonwealth, whether any rational trier of fact could have found the defendant guilty beyond a reasonable doubt.
So what do you have that makes him the joint venturer, other than receiving stolen property and flight, maybe because he had stolen property, or maybe he had drug paraphernalia? What about that behavior is the nexus to the actual break?
So I would first argue that where recently stolen property is found with a person.
2 days later?
1 day later, Your Honor.
1 day later.
And I think the case law is clear that there's no cutoff for what constitutes recent or not. I think that's a determination by the judge. And I think in this instance, the judge did quote case law that where recently stolen property is found on a person, an inference can be made that the person knows the property is stolen and was involved in the theft. So I think that indicates she found this was property that was recently stolen.
I'm sorry, did the case law say, I understand that the case law talks about the inference can be made that the person has knowledge that it's stolen property, but it also indicates was involved in the theft?
I believe the full quote from Rousseau is that there may be an inference of knowledge and involvement in the theft. I could be wrong, Your Honor, but I believe that is the quote. So I think you have that, Your Honor, where the $2 bills and the high number of $1 bills was found on this defendant's person. You have, it's clear from the video and the testimony admitted at trial that there were two people at the scene. I believe there's no question that there was a driver. Given the fact that this defendant's property and his brother's property were found inside of a bag in the victim's home. There were 2 prescription bottles in both of their names. And I think, at least as to the renewed motion for required finding, there's evidence that there was another car where there was quite a bit of property found. It wasn't property that was identified by the victim, but in this car, there were more prescription bottles, both belonging to Peter and Philip Carter, and they're potentially both seen together the night after the break-in. So I think it's a continuing joint venture. They're together, it appears, at multiple points before the stop. And then, of course, you have, I know Your Honor pointed this out, but I think it is significant that this defendant also appeared to give a reason as to why so much of this property was found in the truck that it appears was false. It is circumstantial, but I believe there is enough there to support a reasonable inference that he was the person driving the truck. I will move on to the issue of the prosecutor's closing, and I would argue that while to the extent that the prosecutor was saying the victim's testimony and the officer's testimony was exact, that it was an exact match of number of $100 bills, that was a misstatement of the evidence. And I would argue as to the second point that was raised in the defendant's brief about her statement that there was something unique about the $2 bills. I would say, given the testimony, that was a reasonable inference for the prosecutor to make. However, even if Your Honor has found that both of those statements were misstatements, then I would still argue that there was no substantial risk of a miscarriage of justice, given the strength of the case, and of course, given that this was a bench trial. I think in the judge's findings, she states the number of $100 bills, and I think one could infer that, of course, her memory controlled, and she didn't say the exact match. I think there's an inference that could be made that she realized that the prosecutor had misstated the number of bills and was merely making a comment on the sheer number of $100 bills.
Was there some concern with the government's closing?
And that was, those were the issues, Your Honor. Those two issues, I believe, are those that my sister raised in her brief. And so I would just argue that even if those were seen to be misstatements, I don't believe they rise to a substantial risk of a miscarriage of justice.
On the final issue, can you pinpoint that particular witness's involvement in this case and whether there was any unique involvement that was not covered by another officer?
There was no testimony, and I don't believe at the bench trial that was exactly fleshed out. I think at the motion for new trial hearing, it was clear that the judge, based on what she'd heard at the bench trial and based on the arguments that the attorneys made, that she didn't believe Officer McEachran had any private involvement without Detective Holmes as far as inventorying the evidence. And I know my sister has raised that he potentially was taking photographs of the truck, and I can't confirm or deny that. I'm not exactly sure. My sister could be right on that fact, but I do believe that Detective Holmes was directly involved in the inventorying of the evidence back at the station.
What about was it a license or a passport that was in the cab?
It was, and I think that's the piece of evidence that is the biggest issue here, where...
Was it a big issue as to the case against Philip?
I don't believe so, Your Honor. I think it's clear from what the judge said when she found the defendant guilty that she specifically relied on the $2 bills and the number of $100 bills on the defendant's person, and then kind of generally referenced the stolen property that was in the truck. I don't believe that the passport was as important to her decision.
Detective Holmes said he left the station, so wasn't he involved in the inventorying at the scene where they were apprehended?
I believe Detective Holmes did go to the scene, and it's my understanding that the truck was transported back to the station, and that's where the inventory occurred. I do know that there were some photographs of the truck taken at the scene.
Was he involved in that?
I can't confirm. That's what I can't confirm.
Was there any, what was the mention of the rings?
Yes, so the mention of the rings played...
When did that take place?
So that was mentioned in the Commonwealth's case in chief, and the second day of the bench trial, it was raised, the issue was raised to the judge that this property was never identified as belonging to the victim. So,
but initially, had the Commonwealth suggested that it was?
The Commonwealth had suggested that it was. When the issue was raised before the judge on the second day, the Commonwealth conceded that the property was not identified by the victim, and the judge made a finding to that effect on the record. If there are no further questions, I'll rest on my brief.
Hearing none, the matter stands submitted. Thank you kindly. Well, I think we'll take a brief recess.
All rise, please. Court is now in recess.